Good morning. I think we're about to get started. Can everyone hear me all right? Thank you. Well, welcome to our Hot Topics seminar, the first time we've done this in our newly renovated space up here, which I hope you all have had a chance to walk around and look at and see. We're very happy and proud to be in this new beautiful event space, some of the nicest event space in Cleveland, actually. My name's Jeff Applebaum. For those of you who don't know me, I'm the head of the practice group, the construction practice group, the managing director of project management consultants. You'll hear from folks from both entities today. I want to welcome you and just say a few words that I am supposed to say to make sure I've done it. I was first of all told to tell you where the bathrooms are. Most important, where are the bathrooms? Out there, I know where they are. Out there to the left, a left and a left and a left, and you will find the men's and ladies' room there. Second of all, if you haven't on your parking, we'll validate your parking. If you haven't had that done, see Jenny or see the table up there. They'll validate your parking. Third, for those of you who care about credits, continuing education credits, we have these pre-signed certificates. I just saw them that I've signed. I didn't know I signed them, but these are for you guys if you need your credits. A couple other things. There's some materials up here. I wanted to focus on two things. First of all, for those of you who are project schedulers and want to get rid of your computers, we have invested in scheduling wheels. These are project management consultant scheduling wheels. You can get rid of your computers. You can do your entire schedule effort. You can do a whole CPM schedule just with this scheduling wheel. So that is for you if you need it. And there's also some other materials here for you. So we're going to go through a series of topics today, a couple presentations, a panel discussion, and afterwards we will, you can ask questions during these, but we'll also hang around for Q&A on any of the topics we've raised when we're done. So with that in mind, our newest partner, Erin Luke, I'm going to have you come up here. And Erin is going to, because she actually knows what's going on with this, she's going to act as our master of ceremonies and introduce the speakers as we get started. So Erin.
Thanks very much, Jeff. My name is Erin Luke. I'm a partner here in the construction group at Thompson Hine, and I want to thank everyone for joining both here in the offices and online through the webinar. I just want to remind everyone that we'll take questions at the end. I think that there's also a function on the webinar where you can type questions in. Oh, there's not. Okay, so all questions are at the end, please. Okay, our first topic is called Impact of Tariffs and Trade Issues on Federal and Commercial Construction. This will be presented by Chip Purcell and Jack Clark. Chip is a partner from our DC office in the Government Contracts Practice Group. He focuses his practice on all aspects of government contracts law and litigation with a secondary practice and focus on construction law. Chip counsels clients on issues involving the formation and performance of government contracts and represents clients in pre- and post-award disputes involving the government as well as prime contractors and subcontractors. Jack Clark is an associate in the construction and real estate group. He's going to join Chip in the presentation today. Jack's practice encompasses a variety of real estate, construction, and economic development matters, including public and private financing, acquisitions and dispositions, risk management and commercial leasing, and construction contract drafting and negotiation. Jack has a particular interest in P3 projects as well. So, Chip and Jack, I'll turn it over to you. Do you need this?
All right. Thank you, Erin, and thank you all for joining us here this morning, and hope you're enjoying the views and our new renovations. And so what we're going to do, I'm going to start, give a kind of general overview of tariffs, assuming various levels of understanding on this topic. So sorry if it's elementary for some. Then going to get into the kind of economic impact of these tariffs and then talk about specifically the impact on construction. Then I'll turn it over to Chip, and Chip will focus more on the government contracting side of these recent tariffs. So as you may know, in early March, the president announced that there would be an increase in tariffs on steel and aluminum, 25% increase on steel and 10% increase on aluminum. Recently, there's been exceptions to that increase. It doesn't apply to all countries yet. Canada and Mexico are exempted, and so are European Union countries, and that's for the time being, pending various trade negotiations between those countries and the United States. The tariffs these tariffs are not necessarily new. This is not something that hasn't been tried before. So looking backward, there's been attempts at kind of price control and from international imports through quotas or also tariffs. You might be familiar with tariffs from 2002 to 2005. Ultimately, these attempts at price control generally increase the cost of materials in the market in the United States. The way that the tariffs work is like a tax or a fee, and it causes the international importers to have to charge more to make up that difference. It also allows domestic producers to charge potentially more for their products, because then they can kind of, to be able to remain competitive, they're able to do that. Moving forward, as negotiations come out of NAFTA, and then also negotiations with the EU, we'll have more insight on if the percentages will be the same and to what extent. But ultimately, what this means is that right now there's uncertainty, and uncertainty isn't great when you're trying to price your products. So looking at the economic impact, as I mentioned, generally speaking, tariffs will cause the price of materials to increase. Now, so the tariff on steel is on raw steel, and so as that kind of works its way through the market, this means that products that incorporate raw steel will also see a potential increase. In construction, we look at the structural steel or even rebar. With the aluminum, you have, like I mentioned, there's the 10% increase or a 10% tariff. You might see that in windows or on curtain walls. So it's more than just the raw materials, the impact that it might have. Other items to consider would be your equipment, because there have been already manufacturers of equipment that use steel have said that they fear an increase in costs, and ultimately these costs get passed on to the customer if possible. The companies that are not able to pass these on to their customers, they face a harder time in kind of closing the gap caused by tariffs. There are a couple studies that have come out recently that predict that while there may be some increases in steel jobs, you could actually see a decrease in jobs in both the construction industry and other manufacturing industries, just to try to reduce overhead to kind of combat these tariffs. This is of particular interest to the construction industry. Just to kind of put it into perspective for you, the United States in 2017 imported 33% of the world's steel. Of that 33%, in recent years, the United States has over 40% of the imported steel into the United States has been involved in the construction industry. So the point being that, like, it's real. It's something to at least consider. So as far as the impact on construction, because we hear that there's price uncertainty, there's tariffs. well, what does this mean to me? What does this mean to my project? What does this mean to my project? First off, when there's uncertainty in prices, some of you may know there's uncertainty and estimates. This means that you might see, an owner may see bids coming in higher. You may see subcontractors limiting the amount of time that their bid remains valid. Various controls to try to combat this. But ultimately, the way that these tariffs are handled in the construction industry is largely going to come down to the way that risk is allocated in the contract. The costs increase, like direct cost increases in steel or structural steel, you'll see an increase in your cost of the work. And so depending on how cost of the work is treated in the contract, that could either be passed on to the owner or borne by the contractor. This is important to keep in mind if you're currently negotiating a contract, or if you're looking on the back end, there's an increase of how do I handle this. One of the issues with these changes is that might happen because of this cost increase is just the degree of foreseeability. There's been notice that the tariffs are coming, and there's conversation about the increase. It's hard to predict exactly how much that increase is, and so that's something that, depending on how vague contract language is, it may be hard to determine who necessarily bears that burden. A couple examples that I was seeing where people were actually setting kind of limits in their contract of, if it goes over, if prices increase over this amount, this is how we'll deal with it. You could also see contingency for steel, or you could even remove steel from the equation of guaranteed costs, so that way you could still get contractors to be taking risks in one area, but having the owner and the contractor sharing, or the owner bearing the cost of the increase to steel. Aluminum as well, focusing on steel because that's the large driver here. There's also concerns with delays. If there's delay in the project and there's increase in the cost of steel during that time, who bears the burden there? Largely going to depend on, again, on the contract language and whether or not a contractor has tried to mitigate these efforts or mitigate the increase in the cost. But again, every contract is different, so it's going to be important to be careful with this language, and that's really kind of the point of this update, is to recognize that there is uncertainty in steel and aluminum prices. So there will be uncertainty in pricing. So even though this should always be something that's considered when negotiating a contract, this is just something to be especially attuned to now. Also on the dispute side, because this may not have been, may not have been foreseen at the time if you're already in a contract, it's important to look to see what your force majeure provisions or unforeseen conditions provisions might say. So with that said, those are more generals with commercial construction. I'm going to turn it over to Chip, who is going to explain how these cost increases might be mitigated in government contracts with the federal government.
Jack, let me make one comment on, because I get this question all the time. So right now under standard form documents, if you had a fixed fee contract, a lump sum contract, the thought generally is that you have material cost, that's yours. The argument you make under, for example, a consensus stock is there's a provision that says that you can make a claim for a change in law. But usually it says a change in law that affects performance. So now you have the question, well, is that a change in law that affects performance? And the question I have is that a good argument? And the answer is, when I represent a contractor, yes. When I represent the owner, no. But that is where the argument is. Now, under standard AIA documents and other documents, obviously, if it's a If it is a cost plus or if it's a GMP, clearly that is something you can use contingency for. That is something that you can put in the GMP. But the ability to actually get a change, unless there's something different in the contract, that is going to be dependent on your ability to argue the change in law clause, which has been argued both ways. The funny thing about this, if you're old enough to remember, 30, 40 years ago, when we had big inflationary times, it was pretty standard there in contracts that you would have an escalator provision for materials. As we got out of that, and that's what we had 30 or 40 years ago, and of course you'll hear about this in government contracting, but as we got out of that, that kind of went away in private contracting. So that's really what you're looking at in standard form contract right now.
Thank you. I'm Chip Purcell. I'm a lawyer in the DC office, I think, as you heard. I'm going to talk for a few minutes about the world of government contracting. And I think that the issues that Jack talked about have equal application to government contractors performing construction contracts for federal government customers. The remedies may be different. So as a government contractor, our number one piece of advice that we give to our clients is understand what your contract says, because some of the things that we'll talk about today are contract clauses that may or may not be in your contract. So familiarizing yourself with what the contract says and what your potential remedies are or avenues for relief in case you face price increases based upon the tariffs that we've talked about, you're familiar with those. This slide just reinforces what we've heard before, the president's desire to make a free and fair trade process available. The tariffs are part of it. I'm going to touch in the end about another part of this without going into it in a lot of detail, the domestic preference requirements that we see in contracts, whether it's through the Buy American Act or the Trade Agreements Act. I want to talk about those briefly as well. As Jack talked about, the tariffs are now in play. So we were going to see the risk for contractors using materials, whether it's in a construction project. I mean, obviously, it's not necessarily restricted to construction, but construction is going to be largely impacted by these tariffs. What are the remedies that contractors have available to them when they face price increases, when material costs go up, they're importing steel or aluminum, and they face these tariffs, or as the slide refers to, that there's the domestic impact, whether there are shortages in products as domestic manufacturers or producers of steel or aluminum are ramping up to fill that void, shortages that may come about, and there are price increases that come with all of these events. So in terms of potential risk mitigation, I want to talk about 4 areas where we see potential avenues or of relief for contractors performing contracts for the federal government. All of these come out of contract provisions. So again, my main takeaway is understand what the terms of the contract are, not only what is available in terms of a remedy, but if you want to avail yourself of that remedy, what are the requirements that you need to follow to make sure that you either satisfied some sort of timeliness requirement or the content of what you're asking for, that you communicate it to the government in a timely way, and you can hopefully avail yourself of that relief. The first one is the Federal Acquisitions Tax Clause, which allows contractors to seek a price increase for an after-imposed tax. And the thinking here would be we've got a new duty in the form of these tariffs that the government has imposed upon importers of foreign steel or aluminum. The contractor who's now going to have to pay an increased price because of those tariffs can turn to the government and say, I'm suffering this financial loss, these increased prices, and would like to be made whole through that. That the tax clause would allow the contractor to go to the government and lay out the basis for that, for a request for the price increase based on these tariffs. The thing to know with the tax clause, like many of these clauses, is providing timely notice to the government that you've suffered this financial impact because of the tariffs. When we talk to our clients about using these clauses, a lot of it really just comes down to communication, making sure the government is aware that in performing this work, we foresee. I mean, sometimes it's not just sort of after the fact. It's, hey, government, we see this as something that's coming down the pike. Want to make you aware of it, and we'll keep you apprised as performance continues. So as we know more specifics, that we can tell you what they are. This is a clause that we're going to see more in fixed price contracts. There's not a requirement under the federal acquisition that it be in a cost type of contract. So again, familiarizing yourself with what the contract provisions are. So if this is something that you potentially could be facing, you know whether you can avail yourself of this one or not. The other main clause in the contract that would provide a form of relief for contractors would be the economic price adjustment clause, which allows for upwards or downward revisions in prices based on a number of different contingencies. Here, specifically, the clause that we've highlighted, 52.216.4, labor and materials, speaks specifically to increases or decreases in material costs. So there's a clause that's specific, really, to the kind of scenario that we're talking about here, where there's a tariff that's been imposed on materials. And like the tax clause, there's a timeliness requirement that you need to be able to communicate in a timely way to the government that, hey, here's the cost impact that we see. The other thing with the EPA clause is there's a cap on the level of price increase that you can seek based on the increase in material costs. There's a Department of Defense clause that's specific to as well that actually speaks to steel and aluminum. So if you're doing a contract with DOD and you're looking at increased prices because of these tariffs to steel and aluminum, there is a specific clause in the DOD FAR supplement that speaks to it. Same sort of timeliness requirements, and there's also a cap with it as well. I'll talk briefly about changes claims, and Jeff talked about it briefly too. I think, as Jeff said, the argument is good depending on what side you're on. I think from where we stand, a changes claim based on these tariffs is probably not the best avenue to pursue based on the government's ability, its sort of sovereign right to impose these kinds of tariffs. So there would not be a great argument this is a directed change. The government has told me that I got to follow these tariffs. It's not contract specific. Likewise, the constructive change, we're suffering the impact of increased prices because of these tariffs. You know, it's an argument, but again, probably not the strongest one that can be made. Same with breach of contract. The government has breached my contract because I'm having to pay more money to pay for this steel because of these tariffs. The law permits the government to impose these tariffs. So I think the likelihood of success on a changes claim, or probably a breach of contract claim based on that argument, is not high. Performance impacts likely is apart from the increased prices would be material shortages and the delays that come with them. So as a contractor, thinking about what are your remedies in case there's a delay, the contract default clause, the standard FAR default clause, talks about the contractor's right to seek relief from any sort of penalty the government tries to impose based on failures in performance that are caused by causes outside of their control. I think arguably here, the imposition of a tariff that may lead to material shortages that are going to impact not only your costs, but your schedule of performance would give the contractor a right to seek an excusable delay in performance. I'll touch on it briefly because I know my time is short here. Apart from these tariffs, there's been a renewed focus by the government on enforcing domestic preference laws, both the Buy American Act and the Trade Agreements Act. The Buy American Act, the preference for the use of U.S. produced materials. It's not a prohibition, but it's there's, like a tariff, a financial penalty that's assigned to these costs for these foreign products when the government is calculating the overall cost of someone's proposal to do a particular work. It applies to construction contracts in the $6 or $7 million range and down. I'm sorry, I can't remember the exact number. So below that threshold will be the requirement for contractors to follow the Buy American Act. The Trade Agreements Act is for above that threshold, the ability to use materials from the list of countries that are there at the bottom of the screen. I raised this partly because it's sort of, again, related to the issue of tariffs, but it's an area where the government has increased its enforcement in terms of people's certification that they are compliant with these requirements. So again, as a contractor, understanding what your contract requires and making sure that you're compliant, if you're certifying that you're providing products from a particular kind of country that meets either the Buy American Act or the Trade Agreements Act, that you're actually being compliant. So that's what I have if there are any questions, but yes, sir.
How do you verify how do you substantiate your tariff costs?
I think if you're working with a supplier, asking your supplier to provide, the backup that they've got, that they're paying that tariff-related cost. So if you in turn are going to turn to the government and say, we've incurred these additional costs in buying our materials, being able to have that substantiation, we see this in different forms, whether it's in the form of a tariff coming from a supplier or something in the supply chain where you need that verification. I think part of it can start with your subcontract, where you've got language in your subcontract that's going to require, or your supplier agreement that requires them to provide that information if you need it to be able to substantiate some sort of increased cost. And, a lot of it is just frankly working with those folks, making them understand that we've got a contractual requirement to pass this information on in a form that the government can validate and verify that we've incurred these additional costs, and being specific so you can, find out what they've got to be able to substantiate those costs.
You referenced that the government needs to be notified on a timely manner. What does the government recognize as a timely manner?
Well, it's going to depend upon sort of the specifics. I mean, whether it's an email, we've got an email where you're communicating to a contracting officer or a COTAR or somebody saying, here's the issue. We've got increased costs due to buying materials because of these tariffs.
Okay.
And I think, again, we bring it back to the language of the clause. I mean, if we're talking about we've got this an increased tax in the form of this tariff, we'd like to have the financial relief, that comes with that. We got to satisfy the requirements of the clause. So it's not only the notice, but making sure that the content of the communication meets all of the requirements, that you talk fully about what those requirements are, the specific costs that you're faced, providing the backup that you've got. Email is good because it's verifiable.
Right.
On this day, I told you all about these things.
Right.
You're on notice.
Okay.
So the clock will start to tick.
Thank you.
Mm-hmm. Okay. Thank you very much.
Okay, round of applause for Chip and Jack. Okay, our next presenters are Jeff Applebaum and Bill Thrush. They are going to present the coverage roundup, trending topics, and insurance impacts. So we all know Jeff. He doesn't really need an introduction, but I'm going to do it anyway. Jeff has been practicing construction law in Cleveland for 40 years. He serves as Managing Director of Project Management Consultants, PMC, and partner and chairman of the Construction Law Group at Thompson Hine. He is most well known in Cleveland for his recent work with the Hilton Downtown Cleveland, the Huntington Convention Center, the Global Center for Health Innovation, and the renovation of Public Square. Nationally, Jeff is recognized for his work with 29 professional stadia and arenas, serving in the capacity of owner's representative, project counsel, and partnering facilitator, among other roles. Bill Thrush is going to be joining Jeff today. Bill is a senior associate in the Thompson Hine Construction Practice Group. His litigation experience includes representing clients at trial and in arbitrations, mediations, and appeals involving complex multi-million-dollar construction and real estate matters. Bill is a professional engineer licensed in Oregon and a lead accredited professional in building design and construction. Prior to practicing law, Bill was a project engineer for a global infrastructure and environmental services company where he worked on a variety of public and private commercial and retail developments. A quick plug, Bill and I do a number of short course lunch and learn construction presentations. There's material up here on the table if you want to take a flyer, and we can provide one to anyone participating online. These are complimentary sessions that we do usually over lunch on a variety of topics from claims management to contract negotiation tips. So with no further ado, Bill and Jeff.
I didn't like the 40-year part, just so you'll know. We're going to quickly go through two topics on the insurance front. We're going to talk about a case, the second one, and Bill's going to talk a little bit more about this. And this is one of the two important construction cases that are now in front of the Ohio Supreme Court. And Bill will talk about that. By the way, the other case, just so we're not talking about it today, but the Supreme Court did take jurisdiction to hear the local preference case. So let me just mention what that is. There was legislation passed that essentially made local preference requirements, such as the city of Cleveland has, where you prefer local contractors over other contractors, made that illegal. That was challenged, and predictably, the Court of Appeals here in this area said no, home rule, you can do it. The Supreme Court has taken jurisdiction, so we will now see from the Supreme Court whether local preference requirements of cities and counties are actually legal. So in any event, the first thing I'm going to talk about very quickly is what's happened with the AIA documents. There's a lot that has changed. As you know, AIA comes out with new documents every 10 years, and they are the most preeminent documents, form documents that we use. It's on the 7s. So we just had this in 2017. There is actually a paper that Jack, who you met earlier, Jack and I wrote and presented for the American College of Real Estate Lawyers, and we will, if you want that paper, we'll arrange for you to get it online. It's a comprehensive paper that talks about all the changes in the 2017 documents. The one I'm going to focus on, though, because this is the biggest change, and in 2017, the changes were not revolutionary, but they are evolutionary, and the biggest change has to do with insurance. So what happens in 2017 is there is a new document, which is the A101 2017 Exhibit A. And what basically happens is that what used to be the insurance provisions in a typical AIA contract, whether it is the base contract between the contractor and the owner, or the general conditions, all of that has been, not all of it, but most of it has been extracted and put into this new Exhibit A. And what has happened now is this is a check-the-box form. So you go through this form and you are forced to make decisions about insurance. This form deals with the coverages. It lists all the possible coverages, or most of the possible coverages, and you decide whether the contractor carries that coverage, whether the owner carries the coverage. Who's the party responsible to procure it? What are the minimum limits in every case? And what are the coverage terms and conditions? So the difference between this and what we used to have, in prior contracts, there was just provisions that talked about the claims that you had to insure against. You had to have insurance to cover this claim and this claim, but it didn't tell you specifically what the coverage was, what the limits were. Now in 2017, it's actually you have this coverage, this coverage, this coverage, and this amount. It forces people to make decisions, and not just default. It forces knowledge. So if you don't understand insurance when you get this contract, you take this and you get someone involved who does. The idea about this is, it used to be that if you wanted to go to your insurance broker, you had to give them the whole contract, and they had to look through it, and that was inconvenient. Now what you can do is basically take this as a detachable document, give it to your broker, go through the things, work with your broker or work with your attorney if they understand this stuff, make those determinations. But so that's an easier way to do it. But you can't ignore it, because if you ignore it, you're going to get into some difficult positions. So how is this thing organized? Well, as you might expect, there's one section that deals with the owner's insurance, and one section that deals with the contractor's insurance and bonds. And what you see there in blue is what you have, and there's actually a provision now that deals with owner's general liability, which is something that was kind of ignored before, very clear about what the owner has to have. And it gets into property, obviously, but now there's a series of optional coverages you have to make decisions on. And by the way, the owner can opt out of builder's risk and say that builder's risk is the contractor's responsibility. On the owner's side, it deals with cyber and others. One thing that is not mentioned, by the way, in the policy at all, there's no mention whatsoever of environmental coverage, PLL, pollution liability on behalf of an owner. Often, this is something that the owner should be aware of and understand may be something that he should think about. Now, the reason it's not in the contract is it's not thought to be a matter of negotiation between the contractor and the owner. Nevertheless, an unsophisticated owner can completely not think about this, and that's something that you want an owner to know about. On the contractor side, the contractor insurance comes about in a couple different ways. There's a few policies that are required, but some are simply required if indicated by activities. And this can be tricky. In other words, what you see in red there, these are the ones that are just required. You have to have general liability, you have to have automobile liability, you have to have workers' comp, and you have to have employer's liability. But in yellow are those things that are if indicated. So for example, if you are taking on delegated design responsibilities, you have to have professional liability insurance. In other words, if it's indicated, if you're actually taking design responsibility, you have to have it. Now, the interesting thing about the contract, though, it doesn't say you have to obtain, if you're taking, let's say, design build responsibility, it doesn't say that you have to have your architect or engineer have professional liability coverage. It says you, as the contractor, must have professional liability coverage. And it's not sufficient that you just give it to have your architect and engineer have it. So if this is not something you're prepared to do, you have to modify the contract, and you have to say what this is. So you must understand the coverages and the impact on project risk and cost. If the owner doesn't buy the optional builder's risk policy, you better make sure that it's taken care of, that you've bought it or you've had that discussion, or else you'll have a problem. And then you have the issue as, well, what is indicated and what isn't indicated? You have to have that conversation too, because sometimes that's going to be ambiguous. And this is an example of decisions that would be required. I'll just go through this real quickly. Let's assume, for the sake of argument, that you have a project and your concern is this. If I have a project and I build a wall and I have a wind event, 60 mile an hour wind knocks down the wall, and that's going to delay my project. Now let's go back to the beginning of the project. And let's talk about what decisions you would have made or someone would have made about that event. So what I have here is that, and I don't know if you can read that very well, but that on the right hand, those are the check the box options that you have for the builder's risk coverage. So the first one, loss of use, business interruption, and delays in completion insurance. Well, from an owner's perspective, if that wall being knocked down, clearly a force majeure event, if that delayed my project by 6 months, if I wanted to be covered for my business interruption, for my loss of use, I would have had to have checked that box and paid for the premium. If I don't have any coverage. If during that period of time, when I have to put it back, there's actually a change in the code that said I had to do it a different way, if I have the second box checked, I'm covered. If not, I'm not covered. If during the period of time when that wall is knocked down, in order to get it put back on a timely basis, if I want to pay my builder premium time and overtime to put that back on an expedited basis, I can get that covered, but only if I check that expediting cost box. If I didn't check it, not covered. If when the wall got back up, if even though I tried to expedite it, if I now have a 4-month impact on my project, so that downstream contractors are impacted. In other words, my wall's back up, but now my electrical guy, my HVAC guy, those guys are now 4 months late, and I need to pay them acceleration costs, I can get that paid for, but only if the next box, extra expense insurance, is covered. If I have a problem because of that wind issue, the whole area was shut down, and as a result of that, civil authorities came in and you couldn't work in the area, and that delays my project. That's not covered unless my civil authority insurance box is hit. If I have a more limited issue, my problem is not with the building itself, but because I can't have ingress or egress because of that, I can have that covered, but only if the next box is checked. And then finally, if I'm delayed for 3 months and I have to pay extra costs to my owner's rep or my architect and engineer, those are soft costs. I can get that covered, but only if I have the next box checked. So you might ask yourself, why don't I just check every box every time? And the answer is you might, and maybe on the right project that's important. But you have to talk about the premium risk and also the allocation between the contractor and the owner. But this is just an example of one type of event and why all those boxes, you have to think about it. And by the way, on most projects, a lot of these boxes aren't checked. And I will also tell you that the language in some of these are insufficient. For example, under extra expense insurance, that language is actually insufficient for the coverage you want, because that limits the amount of time that you can get that extra expense to the amount of time that the work is actually being done to fix it. You need to have that coverage after the work is done to fix the wall. That language is not adequate to do it, but you can get by endorsement language which is adequate to do it. What I'm trying to do is not get you to understand all this stuff. I'm trying to get you as contractors to say, get an expert involved to help me with this, because I don't understand what he just said. All right, but that's how this works. A few other highlights of this, policy effective dates. Now, by default under the contract, all coverages must be maintained through the period for correcting work, which typically is 1 year after substantial completion, not simply through final completion, but you have to maintain these coverages through that period for correcting work. There's a whole difference on how notice of cancellation works. I'm not going to bore you with the details, but the old method of 30 days advance notice never worked because you can never get an insurance company to give you 30 days advance notice. So now if there is a cancellation or change in policy, the party holding the coverage that's changed has the obligation to notify the other party within 3 days. There are other issues there. I'm not going to talk about additional insurance because I don't have time. The one I do want to talk about is the last one. This is bizarre. It was always the case that when the owner had the builder's risk policy, the owner covered off-site storage and in-transit coverage. You always relied on the owner to cover those areas where you might have storage and certainly your in-transit coverage. That is no longer part of the owner requirements. There's not even a box for the owner to do that. This is now a contractor obligation unless you do something different. And we're going to have projects where, because that's not realized, there's simply no off-site or in-transit coverage. So that's when you got to worry about and think about and make sure it's taken care of. A few other points. Right now, what the contract says is it says that you have to provide minimum limits. This is probably good for an owner because if the contractor simply says, here are my minimum limits, that doesn't say it's just the limits. It's your minimum limits. You can attack contractor's policy for whatever higher limits they may have. From a contractor's point of view, you should state the limits. These are the limits I have, and these are what I make available to your project. You have this issue of inadvertent or inadequate coverage problem. There's going to be places in the policy where it talks about that you must provide coverage if indicated. There's going to be this debate about whether it was indicated or not. So you have to anticipate gaps, and you have to think about what coverages we really need. Once again, you should have broker or expert involvement. I will also tell you that for some policies, that period of coverage that I talked about just for 1 year, that's not enough. For professional liability coverages and other coverages, you need longer coverage. Obviously, you want completed operations coverage. You have to talk about those things. And then finally, the responsibility to procure builder's risk coverage. don't simply by default say from an owner, okay, I'll just have the contractor do it. Probably not the best idea for an owner in a lot of cases, and make sure you've gone through all of the issues of what these coverages are. So in the time I have, that's all I can talk about with that, because I've been told to be constrained with my time. Bill is now going to talk about the recent insurance case, and when he's done, I'll make just a couple comments on that, and then that'll be the end of our presentation. Go ahead, Bill.
Thank you. Good morning. My name is Bill Thrush. I'm an associate here in the Cleveland office with the construction group, and I'm going to continue the conversation on insurance topics, but I'm going to talk about a specific narrow issue, and that issue is whether defective workmanship is covered under a CGL policy for contractors, a commercial general liabilities policy, and more specifically, whether defective workmanship of subcontractors is covered. And this is an issue that is of much debate across the country, and different jurisdictions are coming down differently on this issue. And the current law in Ohio is unsettled. 5 years ago, we thought we had an answer when the Westfield insurance case came out. We thought we had a bright line rule. The Westfield insurance case dealt with a steel grain mill that was being built. I think it was a Sandusky project. It involved claims of defective work by a subcontractor, and the dispute rose up through the federal courts, and there was an issue of insurance coverage. The insurer denied coverage for the defective work of the subcontractor, and the federal courts certified a question of law to the Ohio Supreme Court. They basically asked the Ohio Supreme Court, we understand that this is unsettled law in Ohio. Where do you come down on this? And it was a very narrow question that resulted in a very broad answer from the Ohio Supreme Court. And I've got an excerpt of the holding from the Westfield case, which says claims of defective construction or workmanship are not claims for property damage caused by an occurrence under a CGL policy. And based upon that determination, the Ohio Supreme Court determined that there was no coverage. However, there was no detailed...
I'm going to interrupt you during your whole presentation. A terrible decision for the industry. A wrong decision, and I will also tell you that the only party represented in this case, the insurance industry, because it was certified to the court, only the insurance industry got to argue this case. No contractor, nobody else argued this case, so they heard from one side of the equation. Keep going, I'll interrupt you again.
Okay. Well, in the Westfield case, there was no analysis or discussion of any of the exclusions or exceptions in the policy, because the court never got to that answer or never got to that issue, stating that there was no initial grant of coverage. Well, fast forward 5 years, and we've got a case coming out of the 3rd Appellate District, the Ohio Northern University v. Charles construction case, and that case said, well, hold on, we don't think that the Westfield insurance case, the holding is as broad as the insurance companies think it is, and they took a look at the exclusions and the exceptions, and we'll get into the details of this particular case in a few minutes here, but they determined that there was, in fact, coverage for defective work of subcontractors under a contractor's CGL policy. And so we'll talk about the details of that case in just a moment, but before we do, I want to take a step back and talk about the typical structure of an insurance policy. And for those of you that attended last year's Hot Topic session, this will be a bit of a refresher, but I want to kind of go through visually how typical insurance policies are structured. So the first thing that you have is an initial grant of coverage, and this is what most people think of when they think of insurance. You pay your premium, you get this initial grant of coverage, which provides you protection for certain types of damages. However, if you flip to the back of almost any insurance policy, you'll see that there are normally a long list of exclusions. And these exclusions serve to reduce or limit coverage in certain factual scenarios. And so visually, you can look at it as the initial bucket of coverage, and somebody is essentially poking a hole in that bucket and removing some of that coverage based upon if certain factual scenarios are met. However, that's not the end of the story either. Many exclusions contain language that is called exceptions, and these are further factual scenarios where the exclusions don't work. And so visually, you can look at this as somebody putting a cup underneath the water flowing out from the exclusions and essentially recapturing some of that coverage. A quick example so you can see how this works in a home insurance policy. You've got your initial grant of coverage, which covers damage to your home. However, many home insurance policies have exclusions for water damage or water infiltration. So if there's damage to your home, yes, you're covered unless that damage was caused by water intrusion. Again, however, a lot of these exclusions have exceptions. So there's an exception to the water damage exclusion if that's caused by leaking pipes. So you buy your home insurance policy, you're covered for damage to your home. However, you might not be covered if that damage was caused by water infiltration, unless that water infiltration was caused by leaking pipes. So how does this apply to a contractor CGL policy? Well, the structure is very similar. You've got your initial grant of coverage, and in a CGL policy, you've got initial grant of coverage for property damage caused by an occurrence. And these two items, property damage and occurrence, are in quotations because they're defined terms in the CGL policy. And almost every CGL policy is the same. There's a standard 1986 ISO form that almost everybody uses. And these definitions will play a critical role in determining whether or not there's coverage under a CGL policy. In the Westfield case, for example, the court focused on whether there was this initial grant of coverage, whether there was property damage, and more importantly, whether there was an occurrence that triggered coverage. And the definition of occurrence is that it is an accident including continuous or repeated exposure to substantially the same general or harmful conditions. And in the Westfield case, the court focused on the word accident and determined that defective workmanship or defective construction was not an accident. It was not an unforeseen, fortuitous event. It was something that was under the contractor's control. Therefore, it was not an accident. Therefore, it was not an occurrence. And therefore, there was no initial grant of coverage that was triggered. What the Westfield court did not do is look further into the policy and look at the exclusions and the exceptions. This is what the Ohio Northern District Court did do. And they looked further into the policy. They looked at the exclusion for your work. And that exclusion states that the policy does not apply to property damage arising out of or any part of your work and included in the product's completed operations hazard. And if you look further into that language of that exclusion, it says that this exclusion does not apply if the damaged work or work out of which the damage arises was performed on your behalf by a subcontractor. So the Ohio Northern Court, in analyzing the CGL policy, looked at the contract as a whole and said under contract interpretation canons, you have to look at the policy as a whole. You have to give effect to all language in that policy. And because there is this exclusion for your work, and there's an exception to that exclusion, in essence, you are recapturing coverage that is performed for defective work performed by subcontractors. And the Ohio Northern Court says that wouldn't be included in the CGL policy. That language wouldn't be in that policy if it didn't mean something. And it wouldn't mean something if there wasn't something to recapture, meaning that defective work by subcontractors must have been in that initial bucket of coverage, must have been.
To be clear, the resulting loss from that work is what we're talking about. So let me just give you a real quick example to put all of these buckets in order. I'll tell you what, here's the problem. So the issue is this. In our building, we have a chase. There's a masonry pipe chase, all right? And behind that pipe chase, there is plumbing, there's piping. And let's assume for the sake of argument that piping was defectively, the pipe itself is defective or it was defectively installed. All right, now, what the original case would say, and as a result of that, what do you have to do? You got to rip out that chase, which is the biggest part of your expense. You got to replace the defective pipe with new pipe, and you got to put the chase back and put all the finish work back. what the Westfield case is trying to say is that this whole thing arose from defective workmanship. Defective workmanship is not an occurrence. Therefore, there's no coverage for anything, which is a mistake, by the way, because defective workmanship, in our view, is an occurrence. Now, put that aside. What does the traditional policy say? What should the coverage be for? Assuming that that work was installed by your subcontractor, the policy says that the work is not covered, your work is not covered, but resulting loss is. So what does this do? It says the following. Number one, the pipe itself is never covered. But if the pipe was installed by your subcontractor, the resulting loss is covered. So what does that mean? It means that you should have coverage, number one, for ripping out all that masonry work, which is a big expense. You're not going to get covered for the pipe itself. No one is covered for the pipe itself because that's a defective product. But putting back that chase is covered. All the finish work is covered. And oh, by the way, if that thing leaked and it caused all kinds of damage to your building, that's all covered. That's what we're talking about here.
You say just the material, pipe material itself.
Yeah. So we don't care. So put up the 1 minute time. You may recall on the Rainforest project, when the Rainforest was done out at the Metro Parks, the whole problem there. Anybody here involved in that project? You're all so young. The problem there was that there were water-bearing exhibits, and there was a gasket, a neoprene gasket, that went between the material, the EPDM material, and some other material. For whatever reason, that thing wasn't water tested. So what happened was they put all these pools in on the second floor, there and these other areas. They then put all the exhibitry on top of it. Millions of dollars of, all this fake, this faux concrete and all this stuff they put on top of it. Then they put the water in and it leaked like shit. And what it did was it damaged everything on the bottom floor. So now we have a dispute with the carrier. Now this is before these cases. And what we said was, you're right, the defective workmanship is not covered. The defective workmanship, or the defective product, if you will, which isn't covered, was this 98-cent neoprene gasket. And we'll take care of that, But all of the loss was covered, all the damage. Ripping out everything to get to the neoprene gasket, that's covered. Putting it back was covered, and then putting back all of that beautiful exhibitry work was covered. That's how this thing typically would work, and that's what we're trying to preserve. Well, we haven't talked about who we are, but that's what this case is all about.
Right, and the facts in the Ohio Northern case are actually about a subcontractor installing flashing and building wrap around openings, and the defective work in that scope of work led to water intrusion, which led to a lot of resulting damage. So the Ohio Northern case, that case was decided by the 3rd Appellate District. It is at odds with the Westfield v. Custom Agri case, and it has been appealed to the Ohio Supreme Court. So it is currently pending before the Ohio Supreme Court. It's been fully briefed, and we are awaiting a decision as to how the Ohio Supreme Court is going to determine how the decision by the 3rd Appellate District squares up with its previous decision in the Westfield case. And again, it's going to involve the interpretation of a lot of policy language as to what an occurrence is, how the subcontractor exception, and how the completed operations language and provisions of the policy affect the coverage analysis. And so many industries have a vested interest in the outcome of this case, which we will hopefully have possibly by the end of the year, including general contractors, subcontractors, and insurance companies. And it could have a significant impact on CGL coverage for defective work in Ohio. So the takeaways are that the current law in Ohio remains unsettled. The Westfield case may not be as conclusive as it first appeared. In fact, it's probably not. And in addition to the law in Ohio being unsettled, this is a topic that's of debate around the country. It's not settled law in many other jurisdictions, so be aware of which jurisdictions your projects are being built in, and what the current status of the law is in those jurisdictions.
Two more comments, and then I'll let you. So first of all, our firm, we're doing the amicus brief before the Supreme Court. We represent Associated General Contractors, AGC, OCA, Ohio Contractors Association, the horizontal construction, heavy highway, and in a rare moment, in a moment of weakness, we're also representing American Contractors Association. So we represent all three in the amicus brief. I will say one thing: if this case goes the wrong way, the issue right now is there's hundreds and hundreds of policies out there that are affected by this. If this goes the wrong way, it will be solved, and the way it will be solved is insurance companies know all about this, and they will make coverage available that covers this risk. They'll just charge an additional premium for it. So that will be the ultimate resolution if this is not resolved properly.
Thank you. Any questions? Thank you.
Okay. Round of applause for Jeff Mills. Okay, we're on to our last presentation of the day. Our final presentation is a panel discussion from Ryan Summers and Tracy Nichols from our PMC Finance Group, and Alan Ritchie, a partner in our construction and real estate law groups at Thompson Hine. The panel will discuss a very hot topic right now, the impact of tax reform on development projects, practical insights, and opportunities. Let me introduce the panel. As Managing Director of Financial Services for PMC, Ryan Summers identifies, secures, and manages private and public financing opportunities for business expansion projects and real estate development. Ryan is currently managing financing for $1.64 billion project pipeline with $440 million in public financing for public-private partnerships, including 1401 Elm in Dallas, Cleveland Terminal Tower redevelopment, Nucleus, Starks Building, Louisville, Standard Building, and many other more projects. Tracy joined PMC after serving nearly 9 years as Director of Economic Development for Cleveland Mayor Frank Jackson. During her tenure, Tracy led her team to complete almost 900 projects, representing nearly $3 billion in investment in the city of Cleveland, and creating and retaining more than 27,000 jobs. Tracy's team also secured financing for nearly $100 million in grants and pass-through funding. Finally, Alan Ritchie is a key partner in the Thompson Hine construction and real estate practice groups. He is one of the founding members of the firm's P3 practice group and served as developer and sponsors counsel on Ohio's first P3 projects. Alan's construction practice includes project delivery counseling, the preparation of all front-end documents, and creating risk management and insurance programs on behalf of owners, developers, architects, engineers, construction managers, contractors, and subcontractors. And he also participates in the resolution of claims. With that, I'll turn it over to the panel.
Just started practicing. Just so you know.
I was 5.
I'm old. Sorry.
Okay, great.
Do we need a clicker?
Oh, we do need a clicker. Thank you, Aaron. Well, first of all, I want to talk a little bit about opportunity zones, and I want to say that I am very excited about opportunity zones. I think that, not to be make a pun, but they're a great opportunity for our region, and I'm going to talk a little bit about why. So Congress wanted to eliminate 1031 exchanges, and they did so for everything except real estate. The real estate lobby was far too strong, and so 1031 exchanges were not eliminated, but everyone should be aware this is something that still kind of has a target on its back, is the 1031 exchange. So the reason they wanted to do that is that they felt that there is a lot of money that's tied up in 1031 exchanges, and they felt that they could free it up, they could help direct it to be invested into lower income neighborhoods, and they could really make an impact in those areas and the people who live in the areas. So it was looked at as a methodology to really free up cash for investment. And the one thing you've got to realize is once you create a fund, it has to be invested in a qualified opportunity zone business. So it has to be targeted to these certain areas. So one of the things, there's a few rules about it. You have a certain length of time. So if you look at a 1031 exchange, which a lot of companies use and a lot of developers, you have 45 days to find a like property, and you have 180 days to close that deal. And I think many people in the room probably realize that in many cases, it's not as easy to find a like property. And in some cases, gain can still be triggered if you decide that the properties aren't like enough, so you want some cash as part of it. That creates an opportunity where you'll have to pay some capital gains right there. But here, we're looking at a period of 180 days from the time you recognize your gain to be able to put the money into a fund. And then Congress is now talking, the rules aren't finalized, and I want to tell everyone in the room that we will have client alerts going out as we learn more, but we have heard that what Treasury is currently looking at is up to 100 and up to 3 years to make the investment. So you've got 180 days to put the money in a fund, and then you have up to 3 years to make a qualified investment in one of these zones. It's got to be cash. You can't put in promissory notes, or in-kind contributions aren't going to be allowed. And one of the most important things for me is they were pushing throughout the country. There was a push to make sure that there was some certification that was required. And if you're familiar with new market tax credits, there has to be a CDE, and there has to be a process with Treasury to get things approved and set up. It takes a very long time. In this case, they've come out, the IRS, there is a ruling that's out, and it's on their website that says that this will be self-certified. So if you want to set up one of these funds, you're not going to wait for, a protracted process to get your fund set up. You can set up a fund. It's self-certified. That means that you're going to have a form that you're going to have to put into your tax return saying that you put money into one of these funds. So that is great news, which means it's flexible and easy to use. So, I guess I should be clicking. That was that. And here's this. So let's talk a little bit about this. What type of business can you invest in? You can invest in substantially any type of business, including real estate. But if you're familiar with SBA, the same type of exclusions that SBA has, no massage parlors, racetracks, businesses that sell alcohol for off-premise consumption, those types of things will not be allowed. Suntan parlors won't be allowed, but just about any other type of business will be allowed. So that is means that there are a lot of opportunities here in Cleveland for what you can put your money into. It has to be, you have to acquire this after 2017 in order for it to be an eligible business, unless, of course, you substantially improve the property. So we've had a lot of questions. I've got a property we just started on, and we acquired it in 2017, but we haven't really done that much. Will that be eligible? And all I can say is we don't know yet, because the definition of substantially improved has not been released. We're expecting guidance in June. Treasury has said they will have information out, but it's not out yet. And again, keep your eye out for client alerts. If you're here today, you'll be on the list to get these client alerts. And as we know what these terms mean, we'll make sure you do. The other thing is that if you want to invest in a company that has a business in a qualified opportunity zone, but it has 2 other locations that are outside of the zone, that's not going to be allowed. It has to be substantially in the qualified opportunity zone. So you have to be aware of that. Companies that have multiple locations, even though one is in the zone, if it's the same company, you can't make that investment and have it count. So that's one thing that you've got to be careful of. So where are these zones? You're now saying, well, great, this is great. I've got a capital gain. I'm going to sell a piece of property or even a piece of art. Your capital gain, by the way, does not have to be from real estate. If you have a personal home you're selling and you're going to realize a capital gain, if you have art that you're selling or some type of collectible and there's going to be a capital gain, that money can be put into one of these qualified opportunity funds and then put into a project. So in December, they announced this, and most tax bills, I think the one in the 80s, they had 3 years of discussion on the tax bill, 3 years before it was announced. I think for this one, it might have been 3 months. And a large part of it was done, I think, in 3 days and 3 nights. And so there's a lot of cleanup that we'll be seeing in rulemaking, because I think Congress might have been a little tired when some of the provisions came out, because there are some contradictions. So governors had 90 days to announce what zones they would select. And these census tracts that were eligible are the same ones basically for new market tax credits. And you could also have contiguous zones, and there was a particular ruling that you could use. You could take a 30-day extension. Our governor did not take a 30-day extension. He asked for input, and I know our firm worked very hard with a lot of our clients to make sure that census tracts in the areas that were eligible, that had projects that were going to happen, we made sure that we got that information in there. And I was very happy. The governor did say that the more people, for every census tract, the more times people said they wanted it from different groups, cities, counties, chambers of commerce, actual developers, community development corporations, the more that they got included, the more likely it was that the governor would make that selection if there was good evidence that there had been past development and probable future development. That's what they were looking for. I get asked all the time, well, why didn't East Cleveland get included? They really need help. It's like they were looking for places that showed that there was development in the past and likely would be development in the future. So places that were the most impoverished were less likely to have investment. And unfortunately, that was the selection criteria that was utilized. So after the governor submitted to Treasury, Treasury had 30 days. I will tell you the website now is showing only about 20 states where the locations are, because many of the states took the 30-day extension, and now Treasury is a little behind. If you want to know about Northeast Ohio, these are the areas that were selected for Northeast Ohio. These are the approved areas. And as you can see, they're clustered around urban areas for the most part, and they're areas that are probably going to have some future development. I will say that Cleveland is very well set up here. Obviously, Health Tech Corridor's in, University Circle, downtown Cleveland, the near west side. So there is a lot of Cleveland that has been included that are areas that are kind of hot for development at this point. So I think that we'll see this helping Cleveland development projects. And so I'm very excited about that. So what can you invest in? You can invest in real estate. You can also invest in venture capital. So this is one of the big provisions that people are excited about. You could direct your money to a company that's a startup and make an investment in that company as long as it stays in the zone for 10 years. That is an eligible investment. And once you cash out of that company, no matter how much you make, it would be tax-free, basically. A direct business investment. So you could make an investment into an existing business into the zone. So you can take a look at that as well. As I said, the business has to stay in the qualified opportunity zone. Obviously, real estate is a good bet, doesn't generally move. But for some of these other ways, I will say that you've got to make sure if you're entering into an agreement with a new company, they have to agree to stay there, because if they move, it's a taxable event to you, the investor. So I believe that this is a much better deal, especially for Cleveland, than new market tax credits. First of all, new market tax credits are oversubscribed. I think it's something like 9 times more projects apply than can be funded. And as you know, it's basically a once or twice a year event. We never know if Congress is going to extend it. It is extended for another year, but it's always on the chopping block. And one of the problems is that there's not a lot of certainty. If you have a project ready to go, you could be waiting, oh, I didn't get it this round, I'll wait till next round, or maybe the next round. I've known projects that have waited for 2 to 3 years before they get an allocation. That's not necessarily a good thing for developers. The other thing is banks at the beginning, after the big foreclosure crisis and the crash, in '08, we found that a lot of banks are very willing to participate in the new market tax credits. And they said, yes, this is a great thing. We'll participate. Unfortunately, now they're not as excited about it. And what I find is that this whole idea of you can't get a real mortgage, you can get an interest, and then at the end of the 7-year period, you'll end up with a mortgage, the springing mortgage concept. Unfortunately, a lot of banks now are saying, well, we're not too keen on that, and we don't like it, and the cost of setting up these the actual organization that will own this property and how you have to set it up has become so much more complex that I think this, which is rather simple, would be far better. One of the things about opportunity zones is you can set up and control your own fund. So if I'm a real estate developer, I sell a piece of property, I have a large capital gain, I put the whole capital gain into a fund. So you're going to put that in, you have 180 days to deposit the money. It's got to be cash, so if part of your gain is not cash, you'll have to put cash into the fund. And you make your money in a couple of different ways. First of all is the time value of money. You get your capital gain tax deferred. So I don't have to pay the government my capital gain. And that means that if I don't have to pay the capital gain for 5 to 7 years, then I have an advantage of using that money again. So if you do hold for 5 to 7 years, you also get a step up in basis. So that effectively is going to save you. So between 5% and 15%. So after 5 years, you've saved 10%. So if I owed the government $100,000 in capital gains, I only owe the government $90,000 in capital gains. And then another 5% after 7 years, so I could save effectively on $100,000, $15,000 of what would be due. So that would give me an opportunity to reduce my tax liability. And then most importantly is this permanent exclusion of revenue that you make on the project. So if you invest in your qualified opportunity zone, so I've put it in my fund, I control my fund, I put it back into my own project. So as you know, if you have a project and you would normally go out and get some type of mezz debt or some type of equity that's costing you a lot of money, you can instead put your own money in through this fund and use it for that purpose and charge a return on that money. But most importantly is at the end, if you sell your project in 10 years, any capital gain on that money is tax-free. So you effectively take the fair market value and at that time, and you increase your basis to that amount. So you have no tax due at that point. So you now get the money tax-free. The one caveat is that it sunsets in 2026. So a lot of people ask about this particular provision. What that means is your capital gains tax that was deferred is going to be due before the 10-year holding period because 2018, 2026, not quite 10 years. So you will have to pay that capital gains tax that was due, and you'll have to pay it from outside of the fund before you can take that 10-year, sell the property, and take it tax-free. So that's the one caveat. There's been some talk about going back. That would take an act of Congress to fix, so just so that you are aware. But it also means that despite the deferral of capital gains, you could also invest your money even all the way up to 2025 and still take a 10-year period to hold it and realize that you would get the increase in value tax-free. So that is one benefit of the particular fund. I think this could be really utilized. I think the fact that developers can invest it into their own project, it means you can control your own risk to the degree that you can control risk on your project. But at least you know it's your money and you're putting it into your project and you're getting the benefit from it. So as I said, we don't have all the rules out at this point, but we will be able to give you some more information through client alerts, and we do think it could be a real positive. So I'm going to pass this over to Alan. Alan?
Thank you, Tracy. Yeah, just one thing on the enterprise zones or opportunity zones, enterprise zones. As Tracy said, 1031 no longer applies to personal property. So basically, personal property in a normal 1031 transaction is going to be treated as boot from now on. So for those folks that have accelerated depreciation in their buildings by doing cost seg studies, which have been super popular for a long time, you've accelerated, a lot of your real property as personal property under these cost seg rules. So the gain on that, if you're doing a regular 1031, you're going to have to pay on. But if you use this structure, you could roll the gain on all those, elements of a building that you accelerated your depreciation on. You can roll it into the next transaction. That's just one little nuance there. So as they say in the development world, please pass the SALT. I thought I'd explain what that means. It's state and local tax incentives. And I'm going to be brief. I'm going to talk about just a really small change that was made to Section 118 of the Internal Revenue Code. And the Joint Committee on Taxation has estimated that this change will generate probably a little less than $1 billion a year over the next 7-8 years in increased taxes. But I wanted to put it a little bit in context instead of just looking at tax code sections. So imagine that you're a small township in Ohio, and over the years you've cobbled together 250 really good acres of land, and you find yourself in a position where you're going to chase a 1 million square foot distribution center that's in the market. There's quite a few of those deals that are floating around because of the Amazon effect. You have one problem though. Your 250 acres is farmland. There's no water, there's no sewer, the roads aren't sufficient, but it is in a perfect location. You are right smack dab in the scatter report for this particular user, which is an out-of-state corporation, by the way. We're only talking about corporations for purposes of this. So as you're to this township, you've got this great piece of property, but you've got a lot of hurdles in order to make your property competitive with all the other sites that are in Ohio. So your job is going to be basically to cobble together or stitch together as many incentives as you can in order to pay for all this infrastructure that you're going to need to bring. So you're going to start with going to the state perhaps, and you're going to get from the state a number of $1 million cash grants or other money, low interest loans perhaps. You're going to consider giving all of this land to this particular 1 million square foot user because of all the jobs that you're going to create in your township. As a township, you don't have the ability to do income tax, so you've got to think about joining a JED or creating a JED. You're going to think about tax abatement, whether it's 10 years, 15 years. You've got the school board. They're completely on board to help get this project. You're also going to think about TIF, which is tax increment financing, where you're taking that increment in value that you've created on this piece of farmland, and you're absorbing it, and you're actually monetizing it to take that money and throw it back into the project. So you're going to go through all of these incentives and try to put together this great package for this potential user of your space. And last year, before the tax change, one of the things you may not have had high on your critical list of examining all your incentives is the tax impact of certain of those incentives on this potential corporate user. And that was because last year there was an exclusion to gross income for things that were non-shareholder contributions to capital, as long as they were being used to try to draw a particular user into your locality or expanding your locality. If those, certain of those incentives, namely like the granting of land or the gifting of land, cash, for example, that corporate user could have excluded that from gross income and they wouldn't have had to pay tax on it. With the tax reform, there was a change to that exclusion. So kind of like Bill's example, you have exceptions to exclusions. Well, what the reform did was they basically excluded or accepted from that exclusion grants of money or land from governmental entities or civic entities were excluded now from that exception. So in other words, now you are going to have to pay tax on those things if you are a corporate user. Partnerships or entities that were taxed as partnerships always basically had to. So if there was an entity, an LLC that selected, to be taxed as a partnership, they were paying tax on a cash grant or land that was given to them for a particular transaction. We would structure those differently in some ways, where we have a corporation that we'd form and they would lease it maybe to the entity. So we would try to mitigate that. But this is important now, and there's an exception that I'll talk about in a second, but this is important now because in the world of putting incentive packages together, like Tracy and Ryan and I do all the time, you're always looking at which ones bear the most fruit. And the other thing is, in your process, you're making decisions early on in what you're asking for. And once you get down the line, if you find out that one incentive is not as valuable as you thought, because now you find out that this particular corporate user is going to have to pay a huge amount of tax on all of these incentives that you had lined up. Well, now it's not as attractive, and your package may not be competitive with others. And it's very difficult to reverse course and go back. So thinking about the impact on your corporate, potential user and what it might mean is really important in how you're structuring your incentives up front. Tax abatement is not considered, it will not be taxable because it's really just a reduction in a tax. TIF, on the other hand, generally TIF, when you have this incremented value of this stream because you still have this entity paying tax, but that money is getting taken and absorbed and perhaps given back to the company in some form or fashion. Generally speaking, it probably is not taxable, but there are instances where if there's not enough expense on one side or the entity doesn't have losses when they're taking in this additional revenue, they might be experiencing some income. So again, there's going to be a balancing in how you're stitching all these things together. And I know for a fact there's a lot of companies that are out there that when they are looking at Ohio, they are looking at the difference between abatement and TIF for that very reason and how it's impacting their project. There's an exception to this rule that is probably yet to be defined. If the granting of land or the cash payment is given, but there was a master development plan. So it's given in, pursuant to this master development plan that was in effect before the end of last year, basically, that will still be excluded from gross income. We really don't know exactly what that means. It could be, a master plan approved by a city. It could be a TIF district created under the ordinance and a development agreement. It could be a number of things. We really don't have that definition yet, but hopefully it'll come out soon. So at the end of the day, there's ways to structure all of these incentives and your transaction in order to maximize the impact of them all. So this is going to be another one I think that is going to float up to the top of the list of things that will critically impact of how you structure them going forward.
Thanks, Alan. I was going to spend a few minutes to talk high level some of the changes that have happened with federal and state historic tax credits. As you look around the skyline, the vast majority of the development activity has been the conversion of obsolete, historic, mostly office buildings, and the primary incentive for that, what driver for that in terms of filling the gap between cost and value has been tax credits. Certainly all the programs that Tracy and her contemporaries at the county and the state, those are important incentives, but between a 20% gross federal historic tax credit and a 25% gross state historic tax credit, 45% of eligible costs are subsidized on a gross basis. So as you can imagine, that's a gap that just can't be filled at the local, county, or state level. Very, very important across the country. So to give you an example of what tax reform has done to our industry, over the last couple of years, U.S. Bank, we all know U.S. Bank. They were the biggest federal historic investor throughout the country in terms of federal historic tax credits. This year, and this is not official, but in terms of the industry, this year through next year, they are out of the market. They're completely out of the market. So you take the biggest federal historic tax credit investor in the country, and you put tax reform in place at the end of the year, and the biggest investor is completely out of the market. So, it goes without saying our industry's pretty much has been dropped on their head, and where everyone's kind of reassessing, okay, what does this mean? Who's in the market? What is pricing? What happens to pricing? What's driving? What's going to be that 45% gap filler going forward? So basically, the federal historic tax credit has gone from a 1-year 20% credit on qualified rehabilitation expenses to a 5-year credit paid ratably over 5 years, so 4% per year. And now you have the whole investor industry that is also has a corporate tax rate that's gone from 35% to 21%. But at the same time, it's bringing in a lot more taxpayers that have liability. So we are right now trying to assess who is going to be in the industry, who's interested in investing in federal historic tax credits. And what we're seeing is that impact to the federal credit going forward is about anywhere from an 8 to 15% discount in value, which is obviously creates additional gap that we now have to solve for. The good news is we do think there will be new investors in the market because of increased liability, and the industry is starting to sort itself out. Transition rules allow for projects that are able to meet basically a window in time for delivery, which basically you have to have the taxpayer and the project in place at the end of last year and start incurring qualified rehabilitation expenses by 180 days, so June 30 of this year, and then finish within a 2-year window, so June 30 of 2020. Our whole industry is mostly seeing what are known as transition rule projects, meaning they could fit within the old code and move forward. So I think I've only seen one term sheet out of the 20 so plus or minus deals that we're working on that are based on the new credits. So I think you'll start hearing a lot more about this issue in terms of the construction, rehab, mixed use industry, because it's going to become a much bigger industry. Conversely, the interesting thing is the state historic tax credit market actually has grown stronger in terms of pricing. Amazingly, we've been very fortunate to be part of anywhere from 20 to 30% of every single state historic project that goes in on a biannual basis. So we're seeing a ton of deals, and we're applying and winning credits. It's a competitive credit in the state of Ohio. And we've seen pricing for the best projects go from 75 cents per credit to the last 2 deals we signed up the last couple of weeks were in the 83 to 84 cent range. So that actually will help make up on the federal side, but not every project has federal and state credits. So those are just a few high-level takeaways. I think it's really going to impact this room because projects can't get off the ground without these in most of the Midwestern markets. And certainly see states like Texas we're very active in that have a unlimited state credit program with a federal program that heavily rely on this now for adaptive reuse and mixed use. So with that, I think it's going to take creativity just to blend in what Tracy said. Actually, opportunity zones may actually have a very positive impact from the federal investor if they can hold the investment longer in terms of their federal credit investment. We don't know exactly what that'll look like, but the technical corrections bill will define that. So we think there'll be some blending of things with what Alan spoke about in terms of SALT and opportunity zones. But it's just one more thing that we have to react to, and we're confident that industry will sort itself out, but definitely will have a short-term impact. It's really almost stalled a lot of projects, but now I think people are starting to figure things out, and the state credit will help make up for that. So with that, I'll turn over to Alan.
All right. I think we're coming back to Mr. Applebaum to do a Q&A. Oh, do you have a last slide?
No, I'm sure.
Oh, no, I don't know. We are done.
Okay, thank you. Well, first of all, thank this panel for their good work. You guys can stay there, though. So what we're going to do now for a few minutes, we will take questions for anything you've heard today or anything else. You know, the 10 minutes of free legal advice on construction issues, any topic you have, up to my age. So any questions for anybody here?
bridge loan for federal historic tax credits for a much longer period of time because he's not retiring, 90% of it at substantial completion. Are you seeing that investors are willing to carry the burden of that, in other words, overcome that huge amount of additional construction period interest, bridge loan interest? Are they willing to reduce the pricing maybe and cover that themselves? Or how are you seeing that play out, especially on these bigger deals?
Yeah, that's a great question. So, historic tax credit projects require typically a bridge loan to allow for historic tax credit equity to be there day one, pay for all these great construction costs that are going to happen, right? So Aaron's question is, what are we seeing in terms of the investors and the lenders and the sponsors being able to bridge this credit now that's over 5 years? Huge issue. So what we're seeing is two things. The senior lender or the sponsor is going to have to step up and bridge that themselves, which means interest over about really a 4-year period because you're going to get the credit in the first year and then have to bridge it. So now you're building an interest. Or the tax credit investors can step up and you're going to have a discounted value. Just like a new market tax credit, it's a 7-year credit, but it only trades for a fraction of the actual credit. So that a $1 new market tax credit rule of thumb is only worth about 21 cents on the dollar. So you're going to see a big discount, or you're going to see a much bigger burden of interest costs on the project. It's really one or the other. But we are seeing options out there. It's going to, again, have that discounted impact, not only on the pricing, but then the carry. So good question, and it's definitely an impact.
That's still in the 8 to 15% reduction that you're projecting, or is that what you're?
It could be in addition to that. So you could have additional carry in addition to the 8 to 15%.
Thank you.
Yes, sir. Jeff, you mentioned under the AIA documents the provision for the effective date that they are now requiring coverage through 1 year after completion.
Well, I said 1 year after completion. It's actually through the correction period.
Now, under the AIA document, the correction period is 1 year.
All right.
But if you were to, by contract, and usually you don't usually see that expanded. Sometimes it's expanded 2 years though. So it's whatever the correction period is, but that is the period that coverage is required to be in place.
My question is that a 2-year policy then? Or is that keep renewing it?
You can accomplish it in different ways.
But I'm also going to tell you
that while that is the default provision, that's not an adequate provision.
For example,
you would never, you would never have a completed operations coverage that ended at that point in time. So,
thank you.
Yes, sir, Charlie.
I had a quick question with regards to the opportunity zones for Tracy in terms of, you had mentioned non-real estate capital gains can be utilized for those investments. As an example, if Alan bought a piece of property, an opportunity zone, and created a fund, but then realized he didn't have enough capital to make it work, and he went out to other private investors for additional funds, and somebody had a non-real estate capital gain, say in the sale of equities, can that person who then takes those non-real estate capital gains invest in Alan's funds and claim that as non-taxable capital gains?
Yeah, the question was if you set up a project and you started it and you ended up in a situation where you needed additional funds, could you go to other investors to invest in your project, and how could that be accomplished? So the answer is yes. So any capital gain that's eligible to be placed into a qualified opportunity zone fund. And you could do one of two things. You could either put the money into the fund that Alan had set up and work that out with Alan and put money into that fund, or you could set up your own fund and then just direct the money into Alan's project. So either way it works.
Sounds great, by the way.
It's a Alan's project.
I'm really excited about where we're going.
He'll take all capital gains and invest them in the project. But no, so it could go either way. You could either set up your own fund or you could participate. I know for a fact, for example, the Cleveland Foundation is looking at setting up their own fund where they have a substantial number of individuals with significant wealth who have routine capital gains who are looking at putting their money, combining it into a fund that will be directed by the foundation, who will then keep track of, say there's 500 people in it, they'll keep track of all the gains and then do that. I know there are other groups that are looking at that as well across the country as making a combined fund. But I think for developers of real estate, one of the things that makes it easy, if you have your own capital gain, you can have your own funds, you can control it, you know where it's going into your project. And as I said, to some degree, you control the risk because it's your project versus putting into a fund with 400 other people and you get some piece, someone else is making a decision of where that money is being invested. The only way this works, and I'll put in the shameless plug, and the only way it really works is if you have a capital gain at the end that you get to take tax-free. That's why this is worthwhile. You're holding it for 10 years, you want to have a return on investment. So that means CMC Finance can help you because up front you want all the incentives that you can get to make sure that that investment is going to have a good return. So I'm just I'll say that, but that's going to be an important part of it. And because of locations of these being in areas that meet these criteria, there are incentives available in most all of these areas. So we're happy to help with that as well.
Other questions?
So Tracy, projects that are currently in the pipe, either getting financed like Playhouse or Nucleus that's been on life support for a while, what does this do for those kind of projects?
So the question is about projects that are in the pipeline right now. So, and whether or not, what would the Qualified Opportunity Zone do for those projects? The situation is that if it hasn't started before January of 2017, and again, there's 2018, there's a provision that states substantial improvements are eligible. So if it started, and we don't know what exactly that term means, but say the only thing that happened is they moved some dirt around and they haven't started construction, we'll assume that's going to be okay for substantial improvements. Then in that case, yes, Qualified Opportunity Zone would be an investment vehicle that could come in. So as I've said, if you're putting together a project in Cleveland, in most cases, you're going to be looking at some type of mezz debt or some type of equity that's going to come into your project, generally at a fairly high interest rate. And so there would be people who would be looking, I would imagine, to invest their capital gains in projects. So it could be an opportunity for those developers to put together some additional cash to help push those projects forward. That's what I'm hoping.
Other questions?
So what happens, Tracy, if you have capital gains, you invest it in a business in the opportunity zone and that business fails sometime in more than 10 years? Then what?
So the question was, what happens if you invest in a project and it fails in within the 10-year period? And while all the rules are not out currently, the benefit of this is if you have a capital gain. So you basically get to increase your basis of your capital gain to the fair market value. So if the fair market value comes zero, you don't have any taxes due because you have no value. So there's that benefit won't be there for you if the project isn't successful. But you still are going to owe, if you have a deferral period on your capital gain, you still are going to owe some capital gains tax after 5 years or 7 years, whatever your hold period is. So that's something just to keep in mind. But that's why I say the only way the Qualified Opportunity Zone works is if there is an increase in value, if there is, you make an investment and after 10 years it's worth more. So that's why I say you have to pick successful projects, and that's why I like the idea of developers being able to invest in their own projects or individuals being able to direct it to a specific project instead of saying, well, I'm just going to invest with 400 other people and someone's going to make a decision for me. I want to know a little bit more about that project and have some control over where the money goes. So I think that we'll see a lot of developers and individuals getting together and working together to move projects forward. And hopefully, most real estate does move forward and do fairly well. And but yeah, venture capital could be, you're either going to make big money or you're going to make no money. So.
Anything else? Other questions? A couple more minutes.
Going once? Going twice? Okay, well, we will hang out here for a few minutes. If you want to ask us questions privately, we'll be here for another 10 minutes or so. Thank you all for coming. We're delighted to have you here. Your certificates can be picked up there. Make sure you have your parking validated, and thank you and have a great day.